I do quite a few of these little speaking engagements. Sometimes churches ask me to talk. I've had credit unions ask me to talk about certain things. So I'll just put a plug out there. If you are a part of an organization and you're looking for a speaker, I'm happy to do it. We don't charge anything for it. And I've got a variety of programs that might fit your guys' needs. I usually held some presentations about once a quarter at the library, but with the library being closed to the public, I'm not able to do that. So I do have a couple of them coming up that are going to be virtually, which I have the dates and the times at the end of the program here. But let me know if you guys ever need a speaker for anything. So I've got a little presentation here. I only have about 30 minutes to talk, and I was trying to talk about a variety of things because elder law, it seems like it's just one small, simple little part of the law, of many different areas of the law, but I really do a lot of different things for a variety of people, a variety of ages. It's not just elders or what you would think of elders. I'll preface this by saying elder law is not my term. The federal law calls somebody who's age 65 or older elderly. My parents are getting pretty close to 65, and they would probably shoot me, quite frankly, if I called them elderly when they hit 65. So that's not my term. The term elder law is not my term, but that's what we use. So I usually refer to my clients as seniors versus elderly. And when somebody comes in and they're in their 60s or 70s, that's still quite young in my world, oftentimes. So I'm going to share my screen here and see if I can get this to work. Woo, there we go. All right, planning ahead for the future. Just wanted to, again, assign kind of a broad topic, and I'm going to fly through different categories and see how much I can get through. If you have questions, don't hesitate to reach out to me. I'm at a lot of chamber events, young professionals events, pretty active in the community. And you could also just call and go out to lunch or have some coffee if you have specific questions. So let me know. I was born and raised here in Hutchinson. As I mentioned, Christine and I went to high school together. So I'm a Hutch High grad. Also went to Hutchinson Community College and then Wichita State. I got my law degree at University of Missouri, Kansas City. I had to start as a paralegal, and I was a paralegal for, I lose track, but 10 years or so before and during law school. I worked almost full-time during law school as well. So I have a pretty big background in the law. Started as a runner in a law firm, which is basically just running legal documents up to the courthouse and running errands, all the way up to being the attorney. And I've done about every job in between. So I have quite a lot of experience. The most amount of experience that I have was in trust and estate litigation. I was a fiduciary paralegal for about 6 years before and during law school, which gave me a really strong introduction to estate planning and the estate planning world. I didn't do much with elder law at that time, and my elder law experience, it's kind of comes and fits right in naturally with the estate planning side of things. But that really has started in the last 3 or 4 years since I became an attorney. Our office is Shepherd Elder Law. Our office is in First National Bank at Sherman in Maine. And I am affiliated with a law firm that's based out of Kansas City. I'm the only other office, a satellite office, if you will. I have clients. So between the Kansas City office and my office here in town, we serve probably most of the state of Kansas. I mean, I just took a couple of clients on out in the Goodland area. I have a number of clients in Garden City and Western Kansas as well. There's just not a whole lot of elder law attorneys. So I've got pretty much Hutchinson and West, and I've even got quite a few clients in Wichita that come up to see us as well. So some essential estate planning documents. When people think about estate planning, they will sometimes think of the last will and testament, or sometimes they call it a living will. And you'll see that I've got both of these separated here. There is a last will and testament. That's the document that people think of when you're talking about passing your property from one person to another after you pass away. That's called a last will and testament. Again, it's often confused with the living will. I like to call the living will just simply the advance directive, because people see the words will and they think they're the same thing, or they'll call up and say, I need a living will. And what they really mean is they want a last will and testament. So I call the living will really the advance directive. Again, the document that passes property from one person to another when you're gone is that last will and testament. Other essential documents, and it's not essential for everyone. I'm not one of those estate planning attorneys who thinks that everybody needs a trust or everybody needs a revocable trust, but there is oftentimes a need for a revocable trust or an irrevocable trust. Again, I don't have a lot of time to really dig right into when do we need a revocable trust or when do we not, need an irrevocable trust, but I've got those other seminars coming up that I'll talk more about those in depth. There's also a general power of attorney and a healthcare power of attorney. Those two documents, along with the advance directive, are three documents that everybody really should have and everybody really needs to have, especially in these times of COVID. The general durable power of attorney, I've had an influx of emergency guardianship cases. And what has happened is that folks, maybe we have a married couple, mom's been taking care of dad, mom passed away because of COVID, dad's now, maybe I've got one situation where mom was covering for dad. The family really didn't have any idea that dad had dementia, to the point that of where dad's dementia had progressed to. He was forgetting to take medications, and it really became a dire situation. In order for the family to be able to get in to pay those bills, certainly you could have a joint owner on a checking account. That comes with other risks involved, but there's a lot more to it than just accessing a bank account. A lot of times people think, well, I've got my kids on my bank account and they can take care of things. That doesn't necessarily allow them to take care of retirement accounts. Maybe you've got a required minimum distribution that needs to be made. What about talking with the insurance company? What about talking about paying taxes, or talking with an attorney, or talking with an accountant, or anyone else, an insurance company? Any of those things, they're going to require you to have a general durable power of attorney. And if you don't have a general power of attorney in place, that's when we're looking at the need for a conservator. And that process is through the courts. It's a conservatorship process. And it's, first of all, you don't get to choose who's going to be that person. If you wanted to do that, you would use a general power of attorney, but the court gets to decide. And then you've got the court all up in your business, and it's a lot more costly. So it's a lot simpler to just go get the general durable power of attorney. The healthcare power of attorney, if you don't have a healthcare power of attorney and we need somebody to make those emergency medical decisions for you, that part is called a guardian. You would need a guardian and a guardianship. And again, the court's all up in your business, and you don't necessarily get to choose who's going to be the guardian for you and who gets to make those decisions for you. So having a healthcare durable power of attorney is really essential. Who's going to make those decisions for you if you're not able to? Oftentimes people would get them from the hospital right before they go into a procedure. That's totally fine. The problem with that is that when you're depending on that durable power of attorney, I would say 8 times out of 10, when I ask somebody, do you have a power of attorney? They say yes, and then they'll pull it out and they'll show it to me. And they think that they have a power of attorney that allows the family member to take care of financial matters and medical decisions. And that's not the reality. That medical power of attorney, that form that you get from the hospital or you get from your doctor's office, that's only a healthcare power of attorney. Not only that, it may not be written in a way that you think it should be written. My power of attorney, the way I write it, it works with my advance directive so that my end of life decisions really can be upheld. And if there's a hospitalist, a doctor that you've never met before who's saying, she's brain dead and we don't even need to bother with the ventilator, but maybe my husband's saying, let's try the ventilator. Well, I've got a healthcare power of attorney that I wrote that says, if there's anything that conflicts with my healthcare power of attorney and my advance directive, I want you to listen to my husband. I want you to listen to my healthcare surrogate under my durable power of attorney. So my documents, they really work together quite well. Again, before COVID, I would tell folks, if you're wanting the quick, cheap, freebie power of attorney, go to the hospital and ask for it, and they'll give you one, or I think the clinic gives them away too. But in the times of COVID, the advance directive and the healthcare power of attorney working together is really quite essential. What do I mean by the advance directive? That's the kind of thing. Do you want to be kept alive? Think about it. If you're brain dead, do you want to be kept alive by artificial means? Do you want a ventilator? How long do we want a ventilator? Do we want to be kept alive if the only thing keeping us alive is a feeding tube? Some of you can think back and remember about the Terry Schiavo case. That was all about a feeding tube keeping her alive. Do we keep her alive with the feeding tube or not? That advance directive is what's going to set forth your wishes. Some people, for religious reasons, they don't normally want to sign an advance directive. There can be, we can write advance directives that also honor those kinds of wishes, where maybe you want to try everything. The idea is put your wishes into writing. Okay. Without that document, the doctors are probably going to err, or the hospital is probably going to err, or could likely err on the side of a very pro-life stance. And so if you don't want to be the person that's what some people would refer to as a vegetable, then you really need to have that advance directive put in place. Probate versus non-probate assets. Again, that guardianship and conservatorship, that is a probate matter. So people think of probate when you're gone and probate for the dead, but they don't realize there's probate for the living as well. And again, that's that guardianship and conservatorship. Both are substantially more costly than if you were to just hire an attorney to prepare you those documents while you're alive and don't have cognitive impairment. Probate and non-probate assets. These are things that we own. Bank accounts, retirement accounts, life insurance, joint tenancy residencies, tenants in common, stocks, bonds, savings bonds, CDs, vehicles, all the kinds of things that you own. It's either going, when you pass away, it's going to fall into one of two categories. It's going to be a probate asset, or it's going to be a non-probate asset. Okay, this again is really a broader conversation, and I have written an article that's on our website that talks about, you know, even if you were to have this really big fancy revocable trust and this great estate plan that I wrote for you, there's ways that you can just thwart it and totally undo what I've done for you by using things like beneficiary designations on accounts. So beneficiary designations are great. What I mean by that is many times banks, some banks will call them transfer on death. Some will call them pay on death, TOD, POD. Some of them will just call it beneficiary. They all mean the same thing, but basically that's a contract between you and the company that says, when I die, pay this over to so-and-so. Okay. If you have a will that says that you want 20% to go to the Hutchinson Community Foundation and 80% to be divided amongst your children, if you've added, and let's say you have 3 children, if you've added one daughter to your bank account as a joint owner, first of all, your 3 children aren't going to get it, because when you pass away, it's going to be the ownership is going to be the sole daughter. It's going to be her account, and she can do whatever she wants with it. Okay. So first of all, you've thwarted that plan, because now your 3 kids aren't going to get it. And you've also thwarted your plan to leave money to the community foundation or to the church or whomever you were going to leave it to. Lorna's on here, we'll say interfaith, right? So the only way interfaith or the community foundation is going to get that money, that 20%, is if you did not have a beneficiary on any of your accounts and you would want it to go through probate at that point. Okay. Most people want to avoid probate, but if you've got those other wishes, that's kind of when we're looking at a revocable trust. And a revocable trust can help us move assets from the probate category over to the non-probate category. But it's really easy for people to not know the legal effects of adding a beneficiary or adding a joint owner to an account. So I would really urge you to talk with an estate planning attorney to talk about those kinds of things. Another thing, I'll give a little bit of free legal advice. I want everybody to go home today and look for your real estate deed. If you own any, if you own your home or you own any other real estate out there, go get a hold of your deeds. If you do not have a copy of your deeds at home, the Register of Deeds office here in town, which is the Reno County Courthouse, the annex, catty corner to the courthouse, go in there and pay them a couple of bucks to get a copy of your deed. What you want to look for, if you own it together with your spouse, so you're married, you want to make sure that your deed does not just say, Marcy, what's your husband's name? Are you married? You're not. Okay. Let's see. Christine's married. I'm going to pick on her. She's my friend. Sorry, Marcy. I didn't mean to throw you under. Christine's husband is Jason. And so Christine's going to go look at her real estate deed, and she's going to make sure that her deed says Christine and Jason John, husband and wife, as joint tenants with rights of survivorship and not as tenants in common. It's got to say that whole long thing. If her deed just says Christine John and Jason John, comma, husband and wife, she's got a problem. And I mentioned this because since moving back to Hutchinson, I've had a number of clients. I've had deeds that are more than 60 years old. I've had deeds that are more than recent, but I've had a number of clients who are married couples and they think that they own property together as joint tenants. And in reality, they do not. They own it as tenants in common. Just having the words husband and wife, or wife and wife, or husband and husband, is not sufficient. It has to say joint tenants with rights of survivorship. What that means is that if Christine were to pass away, that house is entirely Jason's. If he passes away, that house is entirely hers. If it was tenants in common, what would happen is that Christine would own half her house, and now half of the house is going through probate. And that's a problem for folks. So pull your deeds. A lot of the title companies, I'm not really sure why, but there are title issues with some of these title companies with deeds that they're putting out there. So you're going to save yourself a whole lot of trouble if you find out that you own only half of your house while your spouse is still alive. The other thing that you want to do and you want to consider in order to make your house a non-probate asset is that you want to have a transfer on death deed. And that will pass property to your children or to whomever you want it to go to when you pass away without the need for probate. It's going to save a whole lot of money in attorney's fees just by having that transfer on death deed. Again, if you want part of it to go to a charity and part of it to go to the kids or part of it to go here or there or wherever, maybe we need to talk about a revocable trust. But if you're wanting everything to go to the kids and assuming the kids don't have any special needs, they're not disabled, you can put a transfer on death deed on that house. Okay. Many of these other things that I've got listed here, you can put beneficiary designations on. That's going to be your quick, easy way of transferring a probate asset to a non-probate asset. All right, talking about long-term care, and let's see what time it is here. I've got a little bit of time. Okay, so this is really my passion and what I love about elder care. I love the estate planning part of it, don't get me wrong, but this is the area of my practice that I really get to know many of my clients. We're working on a day-to-day kind of conversation very intimately for somewhat lengthy period of time during a really difficult part of their life that they're going through right now. And that's the placement of a loved one into a nursing home. It's not hard. It's not easy for anyone to do that. It wouldn't be easy for me. Nobody wants to put their spouse or their child or their parent into a nursing home, but sometimes we have to do it. And I always tell clients, the biggest compliment that somebody can give me when they come back and they tell me, oh my gosh, I got some sleep last night. I met with you and I finally got a really good night of sleep. And that's because I'm not worried about the financial side of putting my spouse into the nursing home. A lot of people, they hear the term division of assets. Maybe a long-term care facility will say you need a division of assets. and they hear that. They've heard things from friends, from neighbors. They've read things online. They've heard things from the nursing home about what a division of assets is. And I usually tell clients, when you come into my office, you can forget everything you've heard about a division of assets, and we're going to start very much from the beginning, and I'll walk you through it, and there's nothing to be afraid of. A division of assets is strictly for a married couple, and it's trying to protect assets from one spouse to get it to the other spouse, so we don't leave one spouse impoverished. You do not need to get a divorce unless you have a premarital agreement or a couple of other reasons out there, or unless you just want to get a divorce. That old misnomer, there was in the 80s and 90s and before, that you'd have to go get a divorce in order to separate your assets. That's not required and not necessary anymore. We have a solution, and that solution is division of assets. It is not as simple. I didn't get a law degree to help people with division of assets just so they could add everything up and divide it by 2. That's not what it is. Frequently, that's what people think it is that we're going to add everything up and we're going to divide it by 2. There are attorneys in town who will tell people to add everything up and divide it by 2. I had a client that came to me. I'm their 3rd attorney that they came to see. Thank God they found me. And it would have resulted in him spending $250,000 from a retirement account he did not need to spend. So that's a lot of bad legal, really terrible legal advice. You don't have to be totally impoverished to be on Medicaid. It's not just for poor people. It's not what people would think of in that sense. Again, retirement accounts, and there's other accounts and things that don't count. So that's what I'll say about that. Private payment, and I can't stress enough, you want to find somebody when you're working in a long-term care situation with Medicaid. You need to find somebody who doesn't just dabble in this area of law, somebody who works like me, who works in this day in and day out, and we know exactly what Medicaid is doing, and they're saying it's all policy based, based on federal law. What's valid in one state isn't always valid in another state. What we got away with on Medicaid 2 years ago might have changed from this year. It's all just a game, and I play the game day in and day out, so I'm familiar with it. So really getting the expert advice is essential when you're working in this kind of situation. So long-term care payment sources. First of all, we have private pay, and the average in Kansas about $220.50 a day. Here in Hutchinson, we've got nursing homes that range from about $4,500 a month. Probably wouldn't put my loved one in those nursing homes, but they range from about $4,500 a month up to, some of them are like $9,000 or $10,000. And those, when you're getting that high up there, are probably not even actual nursing homes. They're typically memory care units that are maybe even considered assisted living, but they're high level memory care units. Those get to be very costly, very expensive. Long-term care insurance. Some folks have long-term care insurance, veterans benefits, Medicaid benefits, and a combination of some or all of the above. And so I'll talk a little bit about each of these. One thing that you're not going to see on here is Medicare. And what about Medicare? What will Medicare cover? So I'm going to talk just briefly about what Medicare is. Medicare Part A, there's 4 parts of Medicare. Actually, there's more than that, but I don't really understand how they get the different part letters other than the 4 main parts. So 4 parts of Medicaid. Part A is your inpatient hospital insurance. Everybody that is a Medicare recipient receives Part A at no charge, $0. None of the money taken out of your Social Security every month goes to Part A. When you hear about, when you're talking about socialized health insurance and the government really is the largest healthcare insurer, because most all of seniors are receiving Medicare, and then people who are disabled are receiving Medicare about 24 months after they get their disability coverage. So again, Part A covers your hospital insurance and your hospice services. The hospice services have been greatly expanded and improved upon. So That's really good news for people who are receiving hospice services. It's not typically what you would think of as hospice from a long time ago. You'd go on hospice and you pass away very quickly thereafter. I have a couple of clients that have been on hospice services for like 4 or 5 years. So it can be on there quite lengthy. You just have to meet certain criteria. Part B of Medicare, this is the part that you do pay for out of your Social Security check every month. This is the part that covers your health insurance. It covers your doctor's visits, your outpatient services, and your durable medical equipment. Part C is your private Medicare Advantage plans, and it's a private insurance substitute for Medicare. So instead of the government being your healthcare insurer, you use a private company like Blue Cross and Blue Shield. I don't want you to get confused with it supplemental. It's not supplemental. It's truly what they call the Advantage plans. I've seen an increase of people using these Advantage plans, and I'll tell you, it works really well because your premium is like $20 a month instead of being $140 a month or whatever Medicare ends up charging you based on your income. But the problem is you kind of get what you pay for in the long run. A lot of nursing homes, when you are being discharged from the hospital and you get to go to rehab, which I'll talk about here in a minute, those Medicare Advantage plans, some of the long-term care facilities don't accept. And there's some of you who work at these facilities, you might even be able to speak a little bit more to this, but I've had clients had trouble getting into those facilities because they don't accept these Medicare Advantage plans. They just don't pay well. And so you kind of end up getting what you pay for. It's also, you can be denied. And once you have an Advantage plan and you have a sickness or an illness, it's very difficult for you to find an insurance company that it's hard to transfer back to a traditional Medicare plan. So be very careful about signing up for an Advantage plan. That's about all I know and can say about it. But all of my clients that have had them, that have come in, they've not worked well for them. So. Medicare Part D, prescription drug coverage. That's what Part D is your drug coverage, and you are required to have a Part D plan now. Some people don't realize this, but you need to shop around every year during open enrollment to have your prescription drug coverage analyzed. Basically what you do is you take in a list of your prescriptions that you're taking, and you take it to somebody who can look through them and tell you the best Part D plan for you to purchase at that point. And they'll tell you which plan will cover more of your pharmacy costs and which plan has the best premium for you. The Reno County Extension Office used to have somebody there. I was on that board and she's gone, and there's a hiring freeze right now. So I don't think the Extension Office has anyone, but the Department of Aging does. And then I refer a lot of folks to the medicine shop because Rick helps a lot of folks over there to analyze that. So there's a variety of other people out there too, but those are the ones I'm most familiar with. So what will Medicare pay about for long-term care coverage? Part A will cover up to 100 days, and there's an emphasis there on the words up to. Very few people get that full 100 days, and they certainly don't ever, most facilities don't allow people to get to that full 100 days all in one shot. They want you to be able to go home, and if you have another fall and you need to come back and have another surgery and come back to rehab, they want you to be able to have some rehab days for there. So most facilities will not let somebody go fully up to the 100 days. And most of the time people get to a point where they are just going to remain the same. Their baseline, they've hit their baseline and they're not improving. And so Medicare will shut off at that point. And at that point, people go into private pay situation for the long-term care, or they go home. And if you're not well and able enough to go home, then you're looking at that private pay situation at a long-term care facility. I get a drink. One thing to note, and this was suspended during COVID, I think the rule is back to applying. Somebody can correct me on that, but you couldn't be admitted as observation status. Means you had to have a qualifying night. You had to be fully admitted as an inpatient to the hospital for 3 overnights. And if you weren't there, let's say you were there for 2 overnights and half of the next day, if you were discharged to go to a skilled nursing facility for rehab, you're paying for that out of pocket on your own. Medicare is only going to pay for it if you had 3 overnights. Observation status doesn't count. Again, if they're just putting you in the hospital to kind of observe you and they don't have you in admitted as an actual inpatient, Medicare is not going to cover that for you. Medicare will cover the first 20 days in full, and then they'll cover this is a little bit outdated. Obviously, this was for 2020, but they'll cover the next 80 days at 80%. That's typically where if you've got supplemental insurance, the supplemental insurance is going to kick in and cover it. So you're really not paying anything out of pocket for up to those first 100 days if you have that supplemental insurance. Except for this 100-day coverage, Medicare is not going to pay anything for your long-term care costs. That's all you out of pocket on your own from that $4,500 to $8,000 a month. And so you can see why people really find themselves in a financial hardship. If you've got somebody with dementia and they're otherwise very, very healthy and they could live in a nursing home for quite some time, a number of years, you're talking hundreds of thousands of dollars. So it can financially ruin somebody very quickly. The next thing is veterans pension benefits. I am a VA accredited attorney. I think I'm the only VA accredited attorney in, I think from here to Hayes. I don't even know that there's any in Wichita. I work only with aid and attendance. I don't do any of the service-connected claims, service-connected being, they just opened these back up for like Agent Orange connected injuries or disabilities for vets who were in Vietnam or Iraq War vets, you know, any of that kind of service connected things, I refer all of that out. But I do help with the aid and attendance pension claims, which really helps folks with in-home care, assisted living costs, and sometimes nursing home costs. Who qualifies? Again, I do have veterans courses that programs that I put on for people that I go a little bit more into. But the criteria is that you had to have served at least 90 days active duty, at least 1 day during a period of war, discharge other than dishonorable, permanent and total disability over age 65 counts, limited income and assets, which means assets below $130,000 excluding your house. And the surviving spouse must not, so if you want surviving spouse benefits, she must not have remarried after the veteran passed away. You also need to have a need for 2 activities of daily living. So that's your dressing, toileting, transferring, showering, eating, which is not meal prep, or being ambulatory around the home. So that's just kind of that transferring part of it. So 2 or more activities of daily living, or legally blind, or have cognitive impairment, dementia, Alzheimer's qualifies. The amount that somebody can get. So again, this is a pretty substantial benefit for folks, and it helps a lot of people around here in Hutchinson, especially. If it's a veteran with a spouse, so not both spouses have to be veterans, but just a veteran who is married, it's about $2,300 a month that we can get in tax-free income to help pay for in-home caregivers, to help pay for assisted living, or to help pay for nursing home benefit. Sometimes I've had one nursing home that's in Reno County that will say, no, we don't take veterans benefits. And what they mean is they're not a VA approved long-term care facility, meaning they don't take the 100%. Pleasant View and Inman, for example, if you are more than, I think it's 70% disabled through service connected, veterans can go there free of charge. They don't have to pay anything whatsoever out of pocket. And so some of these other nursing homes, when they think of veterans benefits, that's what they think of, and they're not the facility that can accept that. But any facility can accept aid and attendance money. It's just money that comes into the couple and goes straight in their bank account, and then they pay the assisted living facility or the nursing home with it. So it's a big benefit. Single veteran, it's about $2,000. Surviving spouse. So again, a spouse the veteran passed away, but we've got a spouse maybe with dementia or Alzheimer's, there's a benefit for her. And then if the veteran's still alive and healthy, I had a couple of these cases last year where the veteran's still alive and healthy, but the spouse needs a lot of care. We can get about $1,500. It's a base pension amount that can be paid out. So wartime periods, I'll post, I think we have these posted on our website as well. World War II vets, Korean War vets, Vietnam, and then the Gulf War. Vietnam was the only one you had to have a little bit of boots on the ground. And that's at the very beginning of the first couple of years of Vietnam, you had to be boots on the ground. Otherwise, in the others, you could be even stateside. Asset test, I didn't update this dollar amount. I looked at it the other day. It's $130,700. If you have more than that, there's still planning things that we can do. If you want to plan ahead, if you have a little bit more than that, or if you have a lot more than that, there are some things that we can do to plan ahead to look for VA benefits in the future. Can you receive the benefits if you live at home? Yes. There again, you just need those 2 activities of daily living. So it says care costs. A lot of times family members, children are paying, coming in and taking care of mom and dad. We can pay the children, and that just kind of sets aside slush fund so mom and dad have extra money. So Medicaid eligibility, I won't spend too much on this, but the gist of it is you have to be a US citizen, elderly, which is 65 or older, blind or disabled. You have to have less than $2,000 in assets, and your income has to be less than the cost of care. That is for most people. Most people, if your cost of care is $6,000 and your income's only $2,000, well, you qualify there. All of your income goes to the nursing home except for $62. You only get to keep $62. It's a very harsh rule. So a lot of times I have families that call me. It's never too late to do crisis planning. So a lot of times I have families that call me and they're like, oh my gosh, we've spent the last 3 years in the nursing home and we're getting really low on money. We've only got $40,000 or $50,000 left. What are we going to do? We can usually protect about 40 to 50% of that, of whatever's left of that $40,000 to $50,000, and we can set some aside. And you're going to want to do that because $62 a month doesn't cover a whole lot of anything. For most women, it's not even going to cover 2 of their haircuts and sets. So for a married couple, eligibility, we've got to have 1 spouse in the nursing home, and that spouse that's in the nursing home, we usually call the nursing home spouse, and the spouse that's still at home is the community spouse. And so the community spouse is allowed to keep a whole lot more. So sometimes I've got a husband and wife that think, oh my gosh, we got to get down to $2,000. No, you don't have to get down to $2,000. And you don't add everything up and divide it by 2. There's some exemptions of things that don't count whatsoever. That's your house, your car, your personal property, prepaid funeral arrangements. And there's the big one that would have cost my client quite a bit of money last month, and that's that retirement account. Retirement accounts owned by the community spouse in Kansas are exempt. Kansas is one of 7 states that allows that. So retirement accounts owned by the community spouse are totally exempt. A lot of times the nursing home will say, oh, you've got 3 vehicles because, grandpa works or dad works on old cars and we got 2 clunkers that haven't run, but we own them. So the nursing home's worried about it. It's not usually a problem. We can work with that. You can own a home. People say, well, what if my home's worth $1 million? You can have $1 million home. Most people can't afford $1 million home because you have got taxes and insurance and you got limited income. So a lot of that, again, is just salacious news stories and such. So division of assets. I'm going to fly through some of this because it's going to take a lot of time. The community spouse is allowed to keep somewhere between $0 and $126,000. Again, that was a 2020 number. It's slightly increased for 2021. But the most a community spouse can keep is $126,000. Some people see that $126,000 and they'll try to go about a division on their own, and they'll say, well, we had $200,000 and we got it below $125,000, we should be eligible. Nope, that's not how it works. Some people will say, well, before we went into the nursing home, we divided up the accounts and we took his and hers, and I put half of the money in my account, left him with half, and we spent his half, and now we're ready. That's not how a division of assets works. Trying to go about this on your own can be very problematic for you and can result, by the time you figure out you're actually denied from Medicaid, it can result in a $40,000, $50,000 nursing home bill before you know that there's a problem. Here's what an actual division looks like. And again, we're looking at exempt versus non-exempt property, but again, the most that a couple can keep is $126,000 under 2020 rules. Again, crisis planning, I can protect darn near everything for a community spouse. So let's say that our nursing home spouse had a retirement account. Aside from the taxes, I can usually get all of the nursing home spouse's retirement account over to the community spouse, any of those kinds of assets. So paying attorney fees to help in a division of assets case is most always going to save you a whole lot more money than you trying to do it on your own. Exempt asset, non-exempt assets. So things that Medicaid is going to look at when you put in an application, your checking, your savings, CDs, stocks, bonds, mutual funds, savings bonds, oil, gas interests, any real estate that's not your own home, life insurance with cash value. That's the big one people don't realize and they forget about. Again, the retirement accounts, non-retirement investment accounts, cash on hand, inheritance, that kind of thing. Do not try to pull money out and stash it under the mattress. First of all, that's Medicaid fraud. You could end up in the federal penitentiary. I'm not going to help you do it. I would not advise anybody to do it. And there are legal ways to protect assets. So just don't try to do it. And they're probably going to find it. So don't even try. Transfers of assets. At this time, there is a 5-year penalty for transferring assets. A lot of times people will say 3, they'll say 7. It's 5 years. 5 years. If you give money away, you're not going to qualify for long-term care benefits. There are exceptions. And I can help folks save a whole lot of money in these situations as well. Even for a single person, people don't realize, maybe I've got dad who's got 3 kids and one of them's disabled. He does not have to spend everything he has down to $2,000. He can legally save everything that he owns, including his house, and transfer it to a child who has a disability. He can transfer it to anybody. It doesn't even have to be a child, but somebody with a disability. Transfers between spouses are exempt. So again, getting money from nursing home spouse into community spouse. And then there's another big one, and that's the caregiver child. If you have moved in with mom and dad and you've been taking care of mom or dad for the last 2 years or more before mom and dad need to go into a nursing home, we can protect the house without any problems, without look back period. What do we mean by gift? Transferring property for less than fair market value. So if the house is worth $100,000 and you give the house to your daughter who does not have a disability and who was not a child, you just given away a $100,000 asset and you're going to have a problem. If you gave away a $100,000 asset to a child that had moved in with you, you're not going to have you're not going to have a Medicaid problem. You will have a taxable event, however. And that gets into, I thought I had it on here. I might have taken it out, but it gets into a taxable event at that point. So just see your accountant. Still better than losing the house, however. Estate and gift tax threshold. I'm going to clear this up because it's always a pet peeve of mine, and you're going to hear a lot more about it in the news because we've changed presidents. The estate and gift taxation, I'm going to say probably doesn't apply to anybody that's even on this Zoom call. That might be an assumption that is incorrect, but if there's anybody that falls in this threshold, it's not many of you, I promise. And that is because right now the estate and gift tax threshold is over $22 million for a married couple, and it's about $11.5 million for a single person. So that rule that you've heard about giving away $15,000, or some people still are kind of far behind, and they'll say $13,000 or $14,000 every year to anybody, and after that it's taxed. It does not apply to you. It does not apply to you if you do not fall in estate and gift tax threshold, which again, right now is over $22 million. You're going to hear about this in the news. You'll hear about it as a death tax. You'll hear about it as an estate tax. You'll hear about it as a gift tax. The reason why is because under the Trump administration, under the Trump tax reform a couple of years ago, he raised the tax threshold from about 5.4 million per person, which was about 11 million. He doubled it, and that's where we get that $22 million. It was already set to sunset after 5 or 6 years, meaning after 5 or 6 years, regardless of who was president at that time, it was already set to go back from 22 million to $11 million. If nobody does anything, that's what it's going to do. The reason you're going to hear about it is because it's very likely that the Biden administration will allow that to expire and they will not renew it. So in all likelihood, instead of you being able to have $22 million before you hit taxable estate, you will now only go back to being able to have $11.5 million. If you do fall in that $11.5 million threshold, there are planning things that we can do for estate planning purposes to help eliminate gift tax and estate tax at that point, but very few people fall into that threshold. Very few people fell in that threshold before it was raised, and significantly fewer people fall into that threshold now. VA, I mentioned a 5-year look back period for Medicaid. It's a 3-year look back period for the VA. However, that look back period is even a little bit more generous in when it starts and how that period works than the Medicaid rule is. But there is a look back period for VA as well. That went into effect in 2018. So you might hear people say there's no look back period. They're working on pre-2018 rules. Sometimes people just say, I'm going to give gifts away, give money away to my kids, or I'll just deed my house over to my kids so that I can apply for Medicaid in 5 years. That works until it doesn't. And here's some unforeseen situations of when giving money to children can go awry. Maybe the child gets a divorce or a separation, or they have a personal injury suit filed against them. Personal vices such as drugs and gambling, or maybe they simply spend it. Maybe they need to go to a nursing home before you. I've got a couple of clients that are in their 40s that are in the nursing home. Or maybe the kids simply just don't want to give it back to you if you find yourself in the need of a nursing home before that 5 years comes about. So just be very careful. I didn't mention on here, there are significant tax implications for giving property away, certain kinds of property away to your children as well, outside of that estate and gift tax threshold. Here's the dates for my additional seminars that are coming up. March 8th, I'll talk more about the estate planning documents. So that's that revocable trust, the durable power of attorney documents, advance directive, those kinds of things. That'll be March 8th. And then March 15th, I'll talk more about the long-term care and the Medicaid crisis, the division of assets, and how you can protect your assets. That asset protection is really big for folks that want to protect the house, or if they have farmland around here. A lot of times it's a family farm that we're looking to protect. So you've got to do that kind of planning in advance. But again, I've got crisis planning and I've got asset protection planning. To register, just pop us an email or give us a call or check our Facebook page. It's not registration is not required, but we do recommend it. That way we can make sure we've got everyone on the call. And if we have to cancel for some reason, that's happened once. But if we have to cancel for some reason, that way we can let you know. So that's all I have.